Good morning, everyone. So, today we shall be discussing the topic of sealed cover jurisprudence. Sealed cover jurisprudence. You must be having an idea about the sealed cover jurisprudence, isn't it? Good morning, Saksham. Good morning, Soumya. Good morning, Bajasbadatum. Now, before we discuss about the sealed cover jurisprudence, it is important for us to begin with the facts of the topic, the facts of the day. The facts will automatically explain to us the concept of sealed cover jurisprudence. But at least before discussing the sealed cover jurisprudence, you should give me an idea about what is jurisprudence. Good morning, Zinnia. Good morning, everyone. Now give me an idea about what is jurisprudence. Good morning, Damini. Good morning, everyone. Please tell me now, what is jurisprudence? What do you understand by the term jurisprudence? The knowledge of law, as Prableen says, the knowledge of law. Bajasbadatum says the study of law. Okay. The knowledge of law, the study of law. Okay, and there are, the science of law, isn't it? But apart from all these definitions, what have you, first thing, that out of these definitions, what have you deduced? What is the concept? Can you explain it in your language? What is the concept? Zinnia says it traces down the evolution of law. Okay, it traces down the evolution of law. It's important to peruse the evolution of law also as part of the jurisprudence. But what if you are not taught jurisprudence and you are simply taught the substantive law and the procedural law? Will that suffice? Will you be able to develop the legal acumen without studying jurisprudence? Will you be able to develop that holistic legal approach without studying jurisprudence? Is that enough to study and ponder upon only substantive and procedural law? Saksham says it's knowledge of law. Damini says the theory of philosophy of law. Somehow very close. Damini, you are very close to the exact answer. But I want you to explain it in your own terms. Don't simply use those definitions as your conversational crutches. You should come out with your own definitions, your own understanding of the term jurisprudence. Isn't it? That's what I am saying, that without studying jurisprudence, will you be able to develop that legal acumen? That's not right. When we study about the rights, when we study about the crimes, when we study about the property issues, how do we deduce those laws? How do we frame those laws? How do we come to the conclusion that what this is right and this is wrong? This should be punishable, this should not be punishable, isn't it? This is the right of defense, this is not the right of defense. How do you think that stealing something from anybody's house is a theft, constitutes the crime of theft? How do you think that hitting someone constitutes the crime of hurt, or hitting badly someone constitutes the crime of grievous hurt? How did you decipher this? How did you, this must be good, but this is good in terms of general defenses. When you are exercising your general defenses, the philosophy behind it. Knowledge and application of law, Alamelu. Alamelu in Damani's comment is very, Saksham also says philosophy of law. This is exactly what I am trying to explain you. Philosophy of law. Okay. Application of law. Before I begin, I must explain you this philosophy. The philosophy is that, now listen to me very carefully. Listen to me very carefully. Prablin says different jurists have defined law according to the time, and the law has changed with time and needs of society. Exactly. Law is very dynamic, Law is very dynamic. Change is the only constant thing in the society. Change is the only constant thing in the society. And law is made according to the social needs. Law is made according to the social needs. If the circumstances and the needs of the society are constantly changing, the law also needs various amendments and various changes. Probably we would be needing new laws in the times to come, and probably we would be needing new amendments in the existing laws. That is the only way to, walk in tandem with the changing needs of the society, isn't it? So that's what I am saying, that philosophy of law. And every case has a different face. Every case comes with a different face. For example, A murdered B and Y murdered Z. Perhaps A would be punished by the court and he must be given capital punishment, and at the same time Y was acquitted by the court of law and he was not held liable for murder of Z, and it was held that it was committed purely in defense. Both the cases were under section 302 of IPC, but the question was that both the circumstances were very different. The facts of both the cases were very different. You cannot, jurisprudence teaches you to fit the round ball in the round hole only. You cannot fit the round ball in a square hole every time. If you have a round ball and that is very rigid, which is not malleable, anything which is not malleable, law is very malleable. You can mold it according to the circumstances. If it is a square hole, you can make it a square so that it squarely fits into the hole. If it is round, you can make it round. You can make it round so that it is, it roundly fits into the hole. The question is, this is what is taught to us by jurisprudence. We learn this technique, we learn this skill, we develop this legal acumen by jurisprudence, by learning jurisprudence. This is what jurisprudence is, the application of law, the flexibility, the philosophy of law. If we are taught that stealing something is a crime, or hitting someone is a crime, or killing someone is a crime, or fundamental rights are very essential, we cannot leave them by out of our own volition. These are the philosophies which are explained to us by jurisprudence. Okay, now there are so many comments. Xenia says jurisprudence consolidates the various ideologies that the jurists came up with, which help frame the legal system of a country. Jurisprudence is to law what a stage is to a performer. Exactly. Jurisprudence teaches us the philosophy. When we read part 3rd of the Constitution, we come across so many fundamental rights. But what are rights? Why are they essential? What is the significant role played by these rights? These questions are answered by the jurisprudence, isn't it? When we read IPC, a bare perusal of act can make us understand what is a crime and what is not. But the philosophy behind the crime, why a particular act has been made a crime, is answered to us by jurisprudence. Okay. Now, as the Media One case shows, a judiciary that is a mute spectator to any executive action highlights democratic decay. As the Media One case shows, a judiciary that is a mute spectator to any executive action highlights democratic decay. Do you know what is the Media One case? Anybody who can give me a little idea about this Media One case? Anyone who can explain me, who can tell me what is the Media One case? No one? There's a complete silence. Media One is a Malayalam TV news channel in the state of Kerala. Okay? Media One is a Malayalam TV news channel in the state of Kerala that quite often holds debates and question the government of the day, the central government. It has exactly Chitralekha. It's a Kerala-based TV network that was banned. Yes, Madhav Kumar says a Kerala-based news channel which was banned by central government. Exactly. This is the right answer. Malayalam news channel which was banned by the central government, not exactly banned by the central government. Actually, Media One's license was not renewed. The government completely refused to renew the license of Media One TV channel. Okay, and this amounts to a de facto ban only. Okay, if you are not expressly banning a TV news channel and you are simply refusing to renew its license when the license has expired, this is also a kind of de facto ban on the channel. This is because the TV channels which have questioned the government time and again, and which are questioning the policies and laws and the dictatorial style of governance of the central government, these channels have been facing the music since 2014. Just like Amnesty International, which has its headquarters at Bengaluru, had to face so much of vandalism only because and it was holding debates, it was interviewing people who were questioning the government, and it was coming out with so many reports against the governments, that government is resorting to so much of human rights violations in the country since 2014. So these are the kinds of things that has been happening since last few years. So Media One, now Saksham is asking that, sir, appalling means it's very painful. It's really painful. It's menacing. It is distressing, right? Prableen says it was banned during the Delhi riots. Yes, exactly. And now the MIB has decided to not renew their license. Exactly. That's what is happening. Okay. Now Media One, let me tell you that Media One's license has been renewed, and despite after repeated request, and there was also a petition in the Supreme Court in the Media One case. Now let us read it. Media One case, a division bench of the Kerala High Court has dismissed the appeal filed by Media One, a television channel in Kerala, whose license the Ministry of Information and Broadcasting has refused to renew. The ministry had said that the license could not be renewed for reasons related to national security. Now, national security, public order, security of the state, these are one of the listed reasonable restrictions under Article 19(2) of the Constitution. And my research area was this, that when I wrote my master's dissertation, it was on this topic, what are the contextual interpretations that have been accorded to these reasonable restrictions under Article 19(2) time to time, because they are very different in nature. The government has by every means tried to ascribe, the meanings to these reasonable restrictions as per its own convenience. Security of the state, if the government just feels that the security of the state is threatened or the national security is threatened, it might attack anyone's freedom of speech and expression. If it hampers public order, it might attack anyone's freedom of speech and expression. That means proper, concrete, contextual interpretations were never accorded to these reasonable restrictions, and their interpretations were mainly left to the whims and caprices of the central government every time. So that is what has been happening since so many years. We are living in a dilemma, in a state of dilemma completely, because the governments since 1950 have tried to attack the individual's freedom of speech and expression time and again under the guise of ascribing different interpretations to reasonable restrictions under Article 19(2) of the Constitution, isn't it? So, media was never free. The ministry had said that the license could not be renewed for reasons related to national security just because this Media One TV network was trying to question the government. It was trying to question the politicians. It was trying to question, what is the only means of survival of media in today's scenario. If you are not questioning the government and you are simply questioning the opposition, and you are simply questioning the opposition only because the opposition happens to question the government, you should ask the opposition that why do you every time question the government? This is the only formula today to survive in the present scenario. Otherwise, your license will either be refused to be renewed or your license will be simply cancelled. The ministry had said that the license could not be renewed for reasons related to national security. The stand of the government was endorsed by both single and division benches of the High Court. In this context, now the Kerala High Court said that the reasons accorded like means the government's stand was affirmed by the Kerala High Court. In this context, the judgment set a dangerous precedent for free speech rights and procedural justice. In this context, the judgments set a dangerous precedent for free speech rights and procedural justice. Okay? The judgments set a dangerous precedent for free speech rights and procedural justice. Now, suspended rights. A whole set of rights are directly hit by the ban. A whole set of rights are directly hit by the ban. The first is the obvious one. The right to freedom of speech and expression of the television channel. The rights to association, occupation and business are also impacted. Moreover, the viewers also have a right to receive ideas and information. All these rights are altogether suspended by the executive. The only contingency in which these rights under Article 19(1) can be interfered with are reasonable restrictions under Article 19(2). And it's not just, you must be knowing this and you must be having this idea that Article 19(1)(a) does not only comprise of an individual's freedom of speech and expression, but rather this provision is the fountainhead of the entire media law. The entire media owes its freedom of speech and expression to this very provision of the Constitution of India, that is Article 19(1)(a). Okay, and when you are cancelling or you are simply refusing to renew the license of a TV news channel only under the garb or under the guise of national security, preventing national security, okay, preventing national security, then that means you are simply not violating Article 19(1)(a). Not only violating Article 19(1)(a), but along with this, you are also attacking right to freedom of association. You are also attacking right to freedom of occupation and business under Article 19(1)(g). Through such bans, through such prohibitions, through such refusals, and by such callous attitudes of the governments, it's not just one right that gets violated, but a set of rights is hit by such bans and prohibitions. The first is the obvious one, that is the right to freedom of speech and expression of the television channel. The right to association, occupation and business are also impacted. Moreover, the viewers also have a right to receive ideas and information. All these rights are altogether suspended by the executive. The only contingency in which these rights under Article 19(1) can be interfered with are reasonable restrictions under Article 19(2). I understand under Article 19(2) of the Constitution, there are 8 reasonable restrictions which are listed explicitly. But concrete contextual interpretations have not been accorded to these restrictions. Their interpretations are totally depend upon the facts and circumstances of each case. And the governments have tried to accord their own interpretations, as per the circumstances. And the governments have, moreover tried to have, nonetheless, they have tried to, curb freedom of speech and expression by using these reasonable restrictions. Just a small, for example, a small trivial disturbance in the society is happening, and the government says that this is getting, public order is getting disturbed. This is not how the public order gets disturbed. And besides this, containing the public order, containing or preventing the national security or security of the state, or protecting the sovereignty and integrity of the nation is completely the prerogative of the state. The state cannot put these responsibilities completely on the shoulders of the individuals and the media. Although it is important, albeit it is important to control and regulate the media, otherwise media would become an unruly horse. But the question is that these reasonable restrictions under Article 19(2) should be given should be accorded the literal interpretations, and their wider interpretations as has been given to them by the government should be reduced to the literal interpretations. A threat to public order should mean that the public order is seriously hampered. There are serious disturbances in the state. A mere affray cannot be said to be a disturbance in the public order, disturbance of the public order. Okay. Now, among others, like public order, incitement to an offense, it lists security of the state as a ground. Among others, like public order, incitement to an offense, it lists security of the state as a ground. However, the trouble emanating from the media one judgment is that the state need not even show that its security is threatened. It can conveniently choose the sealed cover route. Among others, like public order, incitement to an offense, it lists security of the state as a ground. I have already told you that security of the state is one of the ground. However, the trouble emanating from the media one judgment, is that the state need not even show that its security is threatened. It can conveniently choose the sealed cover route. Okay, a sealed cover route. This is what the sealed cover route is. This is what the sealed cover jurisprudence is. Media one judgment says that the state should not, the judgment in the Media One TV news channel case says that the state is not supposed to prove this. The state is not supposed to even show that its security is threatened. Even just if the state feels that the national security is threatened, it can conveniently choose the sealed cover route and ban the TV news channel, or suppress or muzzle the freedom of speech and expression. Now my question to you is, it's a very clear question. Don't you find a difference between the disturbance in the public order, or the threatening of the security of the state, which is manifest and which can be seen? On the other hand, there is just an apprehension that the security of the state might get threatened. Don't you think there is a huge difference between these two cases? Actual disturbance in the security of the state, when the security of the state actually gets threatened, and on the other hand, there is a mere apprehension on the part of the state that the national security or the security of the state might get threatened. Don't you find huge differences between the two? My question to you is this. Isn't it? Right? Baat jazbaat tum says yes. What about others? Don't you find the difference between the two? On one hand, there is actual, disturbance of the public order. It is happening. It can be seen. On the other hand, there is just a mere apprehension. एक डर है स्टेट के पार्ट के ऊपर that this might happen. Isn't it? Now, the question is that your fundamental rights can be suspended or muzzled only in a case where the public order or the security of the state actually gets threatened. And such threat, such disturbance is manifest. Okay? The government, on the other hand, cannot suppress these fundamental rights or muzzle your freedom of speech merely on the basis of the apprehension that it is having. मुझे feel हो रहा है. The state can say, हमें feel हो रहा है. Why? Do you think this feeling, this apprehension becomes a genuine ground to suppress your fundamental rights? Isn't it? When the government does this on a mere apprehension that it might threaten the national security or might disturb the security of the state or disturb the public order, and the state is not required to prove, the state should be asked in the court that if you say that the national security gets threatened, just prove to us what the Media One news channel has done so far which has threatened the national security and how far you have suffered that loss. You should prove this in the court. You should give the evidence. It should be manifest, na? Any threat to national security must be manifest. Then the state says, no, we were just apprehending this. Nothing of that sort has happened so far, but we are just apprehending this. And when the states are not required to prove this in the court that this was actually happened, this is known as sealed cover route. That the government takes the sealed cover route, it takes the sealed cover jurisprudence. Okay. Now Prableen says, yes sir, when groups incite violence, no such action is taken, and when there is apprehension, the case falls under national security. There has to be reasonable grounds for apprehension also, Baat Jazbaat Tum says. Exactly. Where we are finding a TV news channel which is questioning us, and then we are apprehending out of our own, whims and caprices, that this is going to hamper the national security. Are you serious? These apprehensions cannot become genuine grounds for muzzling your freedom of speech and expression. Things should be very clear. There should be actual threat to the national security, and it should be seen, it should be manifest. It should not be hidden. And the states, when the states are muzzling your voices, it should then prove in the court that actually your national security was threatened, or it was disturbing the public order. These kinds of violent incidents have taken place in these areas because of this. And if this is happening, that's all right. But your mere apprehensions cannot become genuine grounds for suppressing your fundamental rights. Isn't it? And when the state is, when the state is absolved from doing that in the court, it can conveniently choose the sealed cover route. This is known as the sealed cover route. The jurisprudence of sealed cover is an appalling trend. The process of judicial review is significant since it holds the executive accountable. The jurisprudence of sealed cover is an appalling trend. The process of judicial review is significant since it holds the executive accountable. The executive must cogently answer its actions, especially when fundamental rights such as free speech are curtailed. India's constitution does not give a free hand to the executive to pass arbitrary orders violating such rights. The Supreme Court of India has repeatedly held that judicial review of executive action is the basic feature of the constitution. The decisions in Minerva Mills versus Union of India and Al Chandra Kumar versus Union of India 1997 reiterated this fundamental principle. You know, the India's constitution does not give a free hand to the executive to pass arbitrary orders violating such rights. That we are passing this order and this TV channel is now banned simply because we are reprehending that this is going to threaten the national security. This is an arbitrary order. This has no legal basis. This does not comes with a concrete and genuine grounds. And judicial review of executive action. There should be judicial review of executive action. If the executive is taking such actions which is violating fundamental rights, then judicial review to unka banta hai. They are not beyond the scope of judicial review. They are not beyond the purview of judicial review. They squarely fall within the purview of judicial review. And the Supreme Court of India has repeatedly held that judicial review of executive action is the basic feature of the Constitution. This was held in Minerva Mills Limited versus Union of India in 1980. This was held in L. Chandra Kumar versus Union of India 1997, and which reiterated this fundamental principle. If the executive wishes to limit rights, in this case, censor or restrict speech, it must show that the test of reasonable restrictions is satisfied. This principle is the bedrock of judicial review. This is the bedrock of judicial review. You know, it must show the test of reasonable restriction. What is the test of reasonable restriction? When you are coming with an executive action that puts reasonable restriction on any of your fundamental right, then that executive action must have an object, and such restriction must have a close nexus with the object sought to be achieved. Also, there should be proportionality. The doctrine of proportionality should be followed by restricting or suppressing any of your fundamental right. It should be suppressed only up to a proportion which is required. It should not go beyond what is required. Once it goes beyond that, it will violate the doctrine of proportionality and it will be unconstitutional. These are the test of reasonable restrictions and they should be satisfied. And this should not be like this, that the government comes out whimsically with an executive order or arbitrary order, banning a TV news channel suddenly, only because it used to question it, under the guise of saying that this might threaten national security, and that's what we feel, that's what we apprehend. This principle is the bedrock of judicial review. You know, you must satisfy the test of how judicial review is applied. What is the formula? The formula is the test of reasonable restriction. That's what the court applies every time while exercising the power of judicial review. You know, while exercising the power of judicial review, the court applies the test of reasonable restriction. Okay, the Supreme Court says that if the government has come out with an executive action or a law that suppresses fundamental rights, there should be an object of the law. There should be a social need. The society should desperately need such law, and the law should have an object. The object, and if that law suppresses the fundamental right, such restriction should have a direct nexus with the object to be achieved. And secondly, the restriction should come in the exact proportion. The doctrine of proportionality should be followed, and the fundamental right should be restricted, should be suppressed only in up to that proportion what is actually required in a particular case. It should not go beyond that. It should not go beyond that. So have you understood the test of reasonable restriction? Have you understood what constitutes the bedrock of judicial review? I'll move ahead only when you acknowledge me that you have understood so far what I have taught you. Chitralekha says it is like arresting me as a suspect of crime while leaving actual offenders at the scene of crime. Exactly. You cannot even arrest a person on mere apprehensions. You have to collect the evidence. Your apprehensions should be converted into strong beliefs. And that is only possible when the things are manifest in front of your eyes. Okay. Saksham, Bad Jazbat, Prablin, Chitralekha, they all have understood. There are total 16 or 17, 16 people. What about others? Okay, understood. Now the sealed cover practice inverses this position. This is the constitutional position. So far what we have discussed is the constitutional position. The sealed cover practice inverses this position. The moment the executive utters national security, courts often permit them to inform the justification in a sealed cover. Exactly. Now see what a sealed cover is. The sealed cover practice inverses this position. The moment the executive utters national security, courts often permit them to inform the justification in a sealed cover. When the government says that we have done it for the sake of national security, the courts say, okay, that's a confidential matter. You cannot explain it in an open court. Then you do one thing. You give us the explanation in a sealed cover, in a sealed envelope, and we'll read it discreetly somewhere. Everything is, after the national security comes in between, everything is done surreptitiously. And the court say this has come under the sealed envelopes. These are very confidential and sensitive informations. We cannot reveal them in the open court. And national security, all we can tell you is that national security was actually threatened. And so this ban and prohibition or suppression of this particular fundamental rights comes constitutionally. These reasons are not disclosed to the party whose rights are clearly at stake. The court satisfies itself of the defense of the state and dismisses the petition. Media One, the channel that has been censored, is completely in the dark over the reasons for the ban. It was never heard, nor its versions ascertained. It was never heard. The court satisfied itself of the defense of the state. The state takes a defense behind national security. National security is something which has to be kept confidential. The government takes an advantage. It comes under, all the explanations comes under sealed cover, sealed envelopes. They are not supposed to be revealed in the open courts. The court satisfied itself of the defense of the state. Okay, that's a very sensitive issue. Okay, just now the suppression is absolutely constitutional. Okay, go and do whatever you want to do with the fundamental rights of the media and of your people. Can you imagine the situation? This is the situation in a democracy where every person has a right to get informed about everything except the most confidential informations. And I don't know how the Media One TV news network was trying to threaten the national security, a Malayalam news channel who can have access to only the people in the state. How that news channel was trying to threaten the national security. The court, I'm coming to that point, Saksham, just wait. These reasons are not disclosed to the party whose rights are clearly at stake. Media One news channel, for example, while standing in the court, was asking the court and the opposite party, please explain to us how we were threatening the national security. The court and the party said that this was the matter of national security. We cannot reveal these informations to you in the open court, nor even discreetly. So you are not supposed to know this. All you are supposed to know this, that your fundamental rights are suspended. That's it. So I am, as an individual or democratic citizen, am I not supposed to know why my fundamental rights have been suspended? Isn't it? So the channel that has been censored is completely in the dark over the reasons for the ban. It was never heard, nor its versions ascertained. हमें पता ही नहीं है. हमें जब पता ही नहीं है, how we are going to defend ourselves? Endorsed yet blocked. That means This situation, the media once right situation or constitutional position was endorsed. It was affirmed, but yet it was blocked. Okay. The judgment creates a situation that endorses the breach of fundamental rights on the one hand. The court says that yes, fundamental rights are violated. It says, it endorses, it affirms the breach of these fundamental rights on the one hand, and blocks remedy for the victim through a court of law and a process known to law on the other hand. And blocks remedy for the victim through a court of law and a process known to law to the other hand. This is an emulation of the tenor in the judgment in ADM Jabalpur. The majority said in this case that fundamental rights could be suspended during the emergency with no scope for assessment by the court. Unfortunately, the Kerala verdict revives the ghost of ADM Jabalpur. Okay, the majority said in this case that fundamental rights could be suspended during the emergency with no scope for assessment by the court. Unfortunately, the Kerala verdict revives the ghost of ADM Jabalpur. No, okay. Majority in this case, in ADM Jabalpur case, said that the fundamental rights could be suspended during the emergency, and there is not going to be any redressal. And the Kerala High Court in this judgment exactly has done the same. It has revived the ghost of ADM Jabalpur case. Okay. It is affirming, it is endorsing that the fundamental rights are violated, but still it is siding with the government. Consider what the judgment say. The single judge said, from the files produced before the court, it is discernible that the committee of officers took note of the inputs given by the intelligence agencies, which are of serious nature. Some intelligence agencies have given reports against the Media One news channel, and they are of serious nature. These inputs remain unknown. Now, what the intelligence agencies have told to the government was never known by the Media One news channel. In the judgment of 2nd March, the division bench said it is true that the nature, impact, gravity, depth of the issue is not discernible from the files. Still, the bench chose to dismiss the appeals by bluntly saying that there are clear and significant indications impacting the public order and security of the state. All that is necessary to ban a news broadcaster are these indications, which are never revealed to the broadcaster. No recent trend in judicial review has been as opposed to the principles of natural justice as that of the sealed cover. At the High Court, natural justice, right to be heard. My right to be heard as part of natural justice was blatantly violated. How? I never came to know the grounds of the suspension of my fundamental rights. And when I never came to know, I was never in a position to defend myself, and it was an ek tarfa judgment. It was a one-sided judgment, because I was not given an opportunity to defend myself completely, because I never came to know about the grounds on which my fundamental rights were suspended. So at the High Court, national security came to mean absolute impunity for the center. The center was now complete impunity to do anything in the name of national security and muzzle anybody's freedom of speech and expression. The central government exactly audio altrum partum chaitra lekha. The central government virtually wanted the Constitutional Court to abstain from its primary function of review of the legality of executive action, and the court did exactly that. The judgment which accepted this proposition has the potential to mark the beginning of the end of a free press and a working democracy. When an action is alleged to have curtailed fundamental rights, the court is bound to examine the legality of the action through the lens of proportionality. In the modern Dental College versus the state of Madhya Pradesh, the top court adopted the proportionality test proposed by Aharon Barak, the former Chief Justice, Supreme Court of Israel. A limitation of a constitutional right will be constitutionally permissible if 1. It is designated for a proper purpose. 2nd, the measures undertaken to effectuate such a limitation are rationally connected to the fulfillment of that purpose. Okay. Third, the measures undertaken are necessary in that there are no alternative measures that may similarly achieve that same purpose with a lesser degree of limitation. And finally, there needs to be a proper relation between the importance of achieving the proper purpose and the social importance of preventing the limitation on the constitutional right. Okay, this is what I have already explained to you, that these are the tests of reasonable restrictions. This was reiterated in Justice K.S. Puttaswamy versus Union of India 2017. But this entire process of proportionality analysis is sidelined by the court. Okay. Now, for the top court to resolve. Yet the Media One case might create a real problem area that needs resolution by the Supreme Court. The High Court relied on the Supreme Court judgment in DigiCable Network versus Union of India 2019. In DigiCable, the court reiterated the principle in an earlier judgment called Ex-Armaments Protection Services Private Limited 2014. The High Court reiterated what the top court said in DigiCable. In a situation of national security, a party cannot insist for the strict observance of the principles of natural justice. Okay. Now there are two issues here. First, there was no examination of the national security plea based on the proportionality analysis. No exam. That's what I told you. The restriction was not examined on the basis of proportionality, which is well established in our recent jurisprudence. Second, when a 3-judge bench in the Pegasus case, Manohar Lal Sharma versus Union of India 2021, has categorically held that the state does not get a free pass every time the spectre of national security is raised, and that national security cannot be the bugbear that the judiciary shies away from by virtue of its mere mentioning. In view of this subsequent law laid down by a larger bench, the High Court could not have mechanically resorted to the earlier approach in DigiCable. Therefore, the principle, if any, in both DigiCable and ex-armament is arguably implicitly overruled in the Pegasus judgment. No court can read and apply a previous judgment as if it is a statute, but this is what the Kerala High Court did while relying on DigiCable. Understood? Any question here? Okay. What about others? Understood. Okay. Now, a deterioration. Today, we have a state that has succeeded in suppressing the voice of the dissenter, illegally and clandestinely. Okay. Voice of the dissenter was suppressed. Do you know dissent? Dissent is the real freedom of speech and expression in the democracy. Freedom of speech and expression does not simply mean that you are allowed to speak anything. This freedom has always existed in monarchies, in dictators, in dictatorships, and every form of government. You know what is the difference between the freedom of speech in a democracy and freedom of speech in a dictatorship or a monarchy? The real freedom of speech in a democracy lies in the freedom to dissent. You have the freedom to disagree openly with the government. You are allowed to sing against the tunes of the government, not along the tunes of the government. Okay. So the voice of the dissenters are being suppressed. And how? Illegally and clandestinely, discreetly, surreptitiously. The current case will have an impact on any kind of dissent against an aggrandizing regime. Aggrandizing regime, which is involved in self-aggrandizement. which boasts about itself that we are the lords. The current case, we have an impact of any kind of defense like against an aggrandizing regime, including political movements and academic criticisms. We have these political movements. During CA and RC, we saw academic criticisms also. University students participated so vigorously against the CA and the NRC in the NRC protest. A court that sits as a mute spectator to any executive action is a crude manifestation of a democratic decay. And unfortunately, if the judiciary, if the court is a silent spectator and watches the entire drama silently without doing anything, that the governments are suppressing your fundamental rights, the court is a mute spectator, it is silently watching. This situation, it's a brutal, it's very, oppressing and crude manifestation that democracy is decaying. It has staled. Justice Jackson of the US Supreme Court famously said, "Those who begin coercive elimination of dissent soon find themselves exterminating dissenters. Compulsory unification of opinion achieves only the unanimity of the graveyard." Compulsory unification of opinion achieves only the unanimity of the graveyard. Constitutional courts are expected to eradicate such possibilities instead of perpetuating them. Okay? Constitutional courts are expected to eradicate such possibilities instead of perpetuating them. The Justice Jackson of the US Supreme Court said that those governments who try to eliminate people, who try to eliminate dissent from their regimes, who do not tolerate any sort of dissent, any kind of dissent, they start, expelling the dissenters out of the country, exterminating the dissenters. You should go to jail. You should, you have committed sedition, you go to jail. This is what starts in that kind of thing, in that kind of situation. Compulsory unification of opinion achieves only the unanimity of the graveyard. Compulsory unification of opinion means when the government is trying to, create a unified opinion, and that is compulsory, that you have to agree with us. You should, what is your opinion should be the opinion of the public. And this leaves nothing. The government never is successful in unifying the opinion compulsorily. But what happens? What we get the unanimity of the graveyard. People then, they become belligerents. They become insurgents. They try to raise well-established war against the governments. That's what happens. This is what the US Supreme Court Judge Justice Jackson said. Okay, this is what happens. So this is all about the sealed cover jurisprudence. If you have any question, anything to ask, anything to add, you are most welcome to do that. Prudence. Are you sure you don't have any questions? Okay. Okay then. Let's meet tomorrow with another topic. Till then, all the very best. Thank you so much and bye bye.